Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Meor Syamil bin Meor Idris. Today I'm going to present about termination of agency from topic law of agency and from subject commercial law. So this is table of content. There are introduction, objectives and significance of the study, body and conclusion. Okay, first introduction. An agent is defined as a relationship between two parties called principal and agent, whereby the function of the agent is to create a contract between the principal and third parties or to act as the representative of the principal in other ways. Next, agency can be defined as the relationship that subsists between the principal and the agent, who has been authorized to act for him or represent him in dealing with others. So in an agency, there are in effect two contracts. First, made between the principal and the agent, from which the agent derives his authority to act for and on behalf of the principal. And second, made between the principal and the third party through the work of the agent. Three parties that involved in law of agency based on law of agency, Part X, Section 135 until 199, Contracts Act 1950. First, agent, a person employed to do any act for another or to represent another in dealings with third persons. Second, principal, the person for whom such act is done or who is so represented. The third person party, the person with whom the agent brings the principal into a legal relationship. Next is objective and significance of study. Basically, the objectives of the termination of agency is to identify what terms that should we know that could make an agency may be terminated. Specifically, this study is conducted to first, understand how an agency can be terminated. Second, recognize the numbers of terminations that could be made towards an agency. Third, to study a sample case about termination of agency. Fourth, the effects of the termination towards an agency and the other parties. Body. In sections 154 until 163, Contracts Act 1950 deal with the manner in which an agent's authority may be terminated. So in termination agency, there are three ways an agency could be terminated, which is by agreement, by act of the parties and by operation of law. First is by agreement. The first term is an agency may be terminated by agreement on the basis that an agency relationship is created by agreement between the principal and the agent. Such a relationship can also be brought to an end by mutual agreement between the parties, either in writing or orally. So termination could be made when both parties agree that the particular agency shall be terminated. Termination by agreement may also occur if the agency relationship is terminated pursuant to the provisions of the agency agreement itself. The following situations may arise in this context. First, if the agreement provides for the appointment of the agent for a specified period of time, the agency will come to an end automatically when that period of time expires. Second, if the agreement provides for the agency to terminate upon the occurrence of a specified event, the agency will come to an end upon the happening of the specified event. Second is by act of the parties. The second term is an agency may be terminated by act of the parties. For this situation, an agency may be terminated by the acts of either the principal or the agent, as illustrated below. First, performance by the agent. If an agent is appointed to accomplish a particular task or for a specific reason, when the task is accomplished by the agent or the specific purpose is attained, the agency will be terminated. Second, revocation by principal. The authority of an agent may be revoked at any time by the principal. However, unilateral revocation otherwise than in accordance with the provisions of the agency agreement may render the principal liable to the agent for breach of the agency agreement. Any word or conduct of the principal inconsistent with the continued exercise of authority by the agent may operate as revocation of the agency. Third, renunciation by agent. An agent is entitled to renounce his power by refusing to act or by notifying the principal that he will not act for the principal. Fourth, by notice. If the agency agreement provides that the agency may be terminated upon either party serving on the other written notice of a specified duration. For example, 3 months written notice, either party may terminate the agency agreement by serving the required notice on the other party. The third way is by operation of law. The third term is an agency may be terminated by operation of law. An agency may be terminated by operation of law upon the occurrence of the following events. First, where the party concerned is an individual. There are 3 items: death, insanity, or bankruptcy. Second, where the party concerned is a limited company. There are 2 items: winding up or receivership. The third is frustration of the contract of agency. Conclusion. In overall conclusion, there are several ways that an agency may be terminated, which is by agreement, by act of the parties, and by operation of law. For these 3 ways, they also have requirements and conditions that the agency must done in order to get the termination. Moreover, termination in an agency could not be announced or declared immediately without a proper notice and knowledge from the parties that involved. So we hope that termination among agencies could be avoided. It is because we want to ensure that businesses or agreements that have been made between 2 or more companies can be a long term and last longer without having problems and terminations. Thank you.